All right, the final case on this morning's docket is number 127723, State of Kansas Applee versus Andres Mendoza-Rodriguez, appellant from Johnson County. Will the parties please state their appearances?
May it please the court, Grace Tran of the Appellate Defender Office on behalf of Andres Mendoza-Rodriguez.
Good afternoon, Your Honor. May it please the court. The state of Kansas appears by Jacob Gonteski.
Mr. Gonteski, have you entered your appearance in this matter?
I believe I did, Your Honor.
That's fine. You'll check and I'll check and we'll just make sure that we get it.
All right. I had a note on the docket sheet on my bulletin board, but I had every intention.
I remember.
All right. Excellent. So thank you very much for that. Then Ms. Tran, would you like to reserve any time for rebuttal?
Yes, Your Honor, 3 minutes.
3 minutes are granted and you may come forward.
This case originates from a car stop where a substance was found in Andres's car, but due to several evidentiary issues, it's our position that his conviction should be reversed. First, I'll turn to the issue of the lab test results. The district court should have excluded those lab testing results because there wasn't a reasonable certainty that the substance found in Andres's car wasn't materially altered. So after the substance was found in Andres's car during the car stop, the officer went to field test it. And while that was happening, according to his testimony, it basically exploded over the hood of his car as he tried to open the small plastic bag that it was in. He testified that there was a small amount of the original substance remaining in the little plastic bag. And then, there was substance on the hood of his car, which is also where he frequently and usually tests substances on the hood of his car. So he used his gloved hand to scrape the substance off of the hood of the car into an evidence bag, as well as put the small bag with the small amount of original remaining substance in the evidence bag. And so that was what was ultimately tested and what we have the lab report from. And so the district court analyzed this as a chain of custody issue and found that it should be able to be admitted. But for these chain of custody issues, the evidence should only be admitted if there's a reasonable certainty that the thing that is sought to be admitted wasn't materially altered. And here we don't have that. We cannot be reasonably certain that the substance found in Andres's car wasn't materially altered because what was ultimately tested was what was scraped off of the hood of this car, which is where this officer, by his own testimony, frequently field tests other substances. So
do we know if the small bag was tested?
The small bag was put in the evidence bag along with all of the other substance. And I think my understanding is that point it was like ripped open. So everything is in there together. There's not the small bag with the original substance wasn't separate from what was on the hood of the car. It was sort of all together.
And didn't the officer testify the hood of his car was clean?
He testified that, to his visual sight, it was clean, but he also testified that he didn't, specifically examine it for cleanliness before going to field test, the substance. And again, that it was where, as a part of his, as a matter of course, that's where he field tests things. And so I don't think that we can say here that we can be reasonably certain that the substance that was ultimately tested was not materially altered.
Of course, we don't have to be absolutely certain. We just need to be reasonably certain.
Sure.
And so it would seem that if we were to reverse the district court on this, we would have to we'd have to think, well, maybe there was other crystalline substance on his car at the time. That seems like a strange kind of presumption to make.
I don't think it's that strange to say, Your Honor, that if we have a sort of an uncontrolled, not sterile environment where this officer is frequently field testing substances, there could be a substantial risk of contamination where you have substance that's all over the hood of this car that, we're not checking it beforehand to make sure that it's clean, to make sure that there's no contamination happening. And so I don't think that we can be reasonably certain under those circumstances that the substance wasn't materially altered. And
what does our review of that look like?
Your Honor, it's a little tricky, I think, given how it was raised below as a suppression issue. I think that chain of custody issues are reviewed for abuse of discretion. So I think it would be sort of an error of law to say that when the judge found that there was a reasonable certainty that it hadn't been materially altered. And I think
Didn't the quality of the evidence go to his weight for the jury to decide?
I think that's typically in chain of custody issues, although from my reading of the cases, I think that it's sort of a threshold issue, whether, the party offering the evidence can show that there's this reasonable certainty. And then, once that threshold is met, any potential issue, like we said, we don't have to be absolutely certain of, what's going on here. But once we've met that reasonable certainty threshold, then it goes to weight and credibility for the jury after it's been admitted. But I think too, given the facts that the drug dog didn't alert in this case when he went around the car before the substance was ultimately found, given the fact that several weeks before, the same officer had tested a substance found in Mr. Mendoza-Rodriguez's car that tested negative for a substance, I think that all of those things sort of can lead us to not be reasonably certain that there wasn't a material alteration in this case, and so that the lab report should not have been able to be admitted. And that sort of dovetails with the Brady issue having to do with the lack of disclosure of this previous car stop that took place 3 weeks earlier. And so it's our position that the state suppressed favorable evidence and violated Brady in doing so. There was evidence that the defense found pretty close to trial that Andres had been stopped about 3 weeks before by the same officer who stopped him in this case, who found a substance in his car again, field tested it, and it was negative. And so, to violate Brady, we have to have favorable evidence, evidence that was suppressed, and evidence that was material. And I think that all three of those prongs are met here.
Explain to me the materiality, if you will.
So when we're looking at materiality, we're looking at a reasonable probability the result of the proceeding would have been different. And I think, so when we're having this, nominal suppression hearing that deals with the car stop as well as the lab report, with the lab report portion, the district court is being called upon to determine the reliability of this evidence. And I think, as well as bad faith determinations of, how did this happen that this evidence sort of ended up in the state that it did. I think knowing that the same officer had stopped my client 3 weeks earlier, found a substance that he thought was illegal, field tested it, and it was negative, that there's a reasonable probability that the result of the hearing would have been different given that information, because
Why?
so the defense attorney could have used that that evidence, one, to go toward good faith or bad faith in that situation, given the previous encounter that the officer had with my client, as well as to impeach.
So are you saying the state has an obligation to provide a defendant with every time he or she's been stopped?
No, Your Honor, but I think that given this case and given the specific facts of the case, that the sort of reliability and the evidence handling was in question, I think that makes this prior stop relevant. And the defense did ask for, exculpatory evidence to be turned over, and it wasn't. And so I think under these specific facts,
I'm having a difficult time figuring out how that evidence is exculpatory, because here's what I keep coming down to is that, so he was stopped and by the same officer. The officer tested this substance that the officer thought was what we have here, came out that it wasn't, and no charges were filed. So how is that exculpatory as to this stop?
right. So in this stop, the officer's, ability and evidence handling skills were what was in question at the suppression hearing in regards to this lab report, and, whether or not we can rely on this evidence. And so I think the officer's, previous, being incorrect about the evidence that he had found in that case, or in that what didn't become a case, that goes toward the reliability and his ability to make determinations about the evidence and his evidence handling practices in this case, as well as the fact that the defense attorney argued or asked the district court to evaluate if there had been bad faith in the case. And I think having the history between the parties in question, that was necessary for the district court to be able to fully evaluate the presence of bad faith during that interaction and in the evidence handling.
So, but at the end of the day, the defendant had this information before trial. Was there a request to the district court to reevaluate the suppression finding given the new evidence?
I don't believe that there was an explicit request to sort of have a do-over on the suppression hearing with this new evidence. I mean, I think it was pretty close to trial. And I
had in mind it was within a week.
I think that is correct based on my recollection. And I think that sort of goes to the reasonable time prior to trial that was referenced in the state's brief and sort of this discussion of, do we have to turn over this evidence, at this point pre-trial? And I think it's a reasonable time prior to trial to turn over evidence that's relevant to a dispositive motion, like the suppression motion, or, if we characterize it as a limine motion or something along those lines, maybe not dispositive at that point, but certainly relevant to the trial, that it was reasonable for the state to have turned those things over.
And that report of that previous stop, that's not in the record on appeal, is it?
No, I don't think so.
Okay. So it's difficult for us to evaluate the contents of that report to see it potentially would have impacted the district court.
I think that the sort of what we have proffered in the motion that the defense filed, as well as the discussion on the record in the case, is sufficient for this court to be able to review whether or not that report, is material, is favorable. Just given we have a good amount of information.
And quite honestly, wouldn't your client have known that he got pulled over 3 weeks earlier? Didn't he have this information already?
I think that it's fair to say that he would have known that he had gotten pulled over, but I don't think it's fair.
Charges had not been filed against him.
Sure. I don't think it's fair to say, though, that a layperson would know the legal import of that and the way that could be used in a suppression hearing, used as impeachment material. And so, maybe there was an assumption that his defense attorney would have already known that he had gotten pulled over by the same officer weeks before. So I don't think just because my client, he was there, he would have known that relieves the state of their duty to disclose that information. And unless there are further questions, I would submit the remaining issue on the brief. And thank you.
Other questions from the panel? All right, thank you, counsel. We have 3 minutes for rebuttal, so we'll look forward to seeing you again.
Good afternoon. May it please the court. I'm Jacob Gonteski. I represent the plaintiff, the appellee, the state of Kansas here. I will do my best to be as faithful to the clock as opposing counsel was. That was impressive. Judges, this case comes before you with no reversible error. Officer Steele conducted a routine traffic stop just outside the courthouse here that night that brought about the charges against this defendant. And throughout that traffic stop, at all pertinent times, Officer Steele adhered to all of the legal requirements to pursue the investigation that led him down the path, ultimately finding a baggie of meth inside the defendant's possessions. At every step of the way, Officer Steele had the requisite reasonable suspicion or probable cause to pursue the investigation that he did. It began with a traffic infraction, and when he stepped to the side of the defendant's car and looked inside, he confirmed the infraction offense. And within seconds of putting eyes on the defendant, he spotted the bottle of Fireball whiskey in the center console. Right at that moment, he had probable cause to believe that a misdemeanor offense had been committed by the defendant. And at that point, he had probable cause that would support a search of the vehicle for evidence of the crime of transporting an open container. And so that's the path that he went down. While he was at the side of the car, that's when he radioed for backup, because as he testified in the suppression hearing, policy requires that he has backup with him when he's going to conduct the search of a vehicle. So within a minute or two of his opening interaction with the defendant, he radios for backup, and he learns that the canine unit is the closest backup to him. The canine unit has the canine that can obviously do an open air sniff, but the canine comes with an officer who can serve as the backup that Officer Steele needs to conduct the actual physical search of the vehicle. And at every step of the way, officers.
What exactly was the point of conducting the physical search of the vehicle if the crime was transporting an open container and I, as the officer, see the open container?
What he was going to need to do is he was going to need to retrieve the open container out of the vehicle, because he had the passenger and the defendant step out of the vehicle when he observed it when he was at the side of the car, and then he radioed for backup, and then he retreated to his car to run the name for wants and warrants. The driver did not have a driver's license with him, although he did recall it in the opening sequence between Officer Steele and the defendant that they both realized that they had interacted with each other a few weeks prior. So in the body cam, you see as much. But he retreated back to his patrol car to run for wants and warrants. And when he did that and radioed for backup, he began drafting up the infraction for the transporting the open container. Backup arrived. He stepped out of his vehicle. When he went up there to conduct that search for the bottle was no longer where he had first seen it in the center console. It had been secreted away somewhere. And so now it was incumbent upon Officer Steele to locate the bottle where it was in the vehicle. So they opened up the doors and began a search of the vehicle for that bottle. They had probable cause to do so every step of the way. And so the canine sniff did not unreasonably extend the stop. It didn't extend the stop because the canine sniff didn't even occur until after Officer Steele already had probable cause to allow him to search the vehicle for evidence of the crime of transporting an open container.
Was it even necessary to do a canine sniff? He already had probable cause to search the car?
It was not necessary. No, but Officer Steele was still acting within his legal authority to do so, given that he had probable cause to search the vehicle. We've often had officers testify in other cases once they establish probable cause, such as the odor of marijuana or something of that sort. They'll often call in the canine to conduct the sniff because their search of the vehicle will be much quicker. It'll be much more efficient with the use of a canine, because the canine in those cases will often zero right in on where the evidence can be found. So that will prevent the need of the officer from tearing apart the entire car, looking for where the smell had come from.
But of course, here it was looking for alcohol, and the canine would not sniff for alcohol.
Correct. The canine would not sniff for alcohol. The officer was looking for alcohol. When he was looking for alcohol, then he noted that he observed what he believed to be a small amount of marijuana beneath a bag on the passenger, I believe it was on the passenger floorboard. A canine could detect that. Wouldn't always necessarily detect it, but could.
And did not hear.
And did not hear. The canine did not alert here. The officers continued conducting their search of the vehicle and recovered the evidence that they did, and then placed the defendant under arrest at that time. So at all relevant times, the officer was acting under the authority that he was allowed under the law. Additionally, the lab test results were properly admitted. The motion to suppress hearing is where the district court heard evidence from Officer Steele about how the field test was conducted. And it's shown on his body. It was all preserved on his body cam as well. He testified that he often conducts field tests on the hood of his car. It's the easiest place for him to do it. He doesn't like to do it in his patrol car. That's not safe in case there's fentanyl. He doesn't want to be in an enclosed space. The hood of his car provides a relatively flat surface, a desk of his office. And so when he stepped over to his patrol car to do that, he did it in front of his body cam the entire time. And he testified to the fact that the white crystalline substance that he had seized from the car was wrapped in a very small plastic. It appeared to be the remnant of a plastic bag that had been sealed. And he discussed it may have been melted or burned together. So it was held very tightly in that plastic. And when he stepped to his patrol car to conduct the field test of that substance, he had the field testing kit there that he testified only needs a very, very small amount of the substance to conduct the field test. And he went to open the plastic baggie. And when he did so, it tore open and the substance spread all over the hood of his car. And so he then undertook an effort to scoop it back up. He had a gloved hand. His backing officer had a new Ziploc bag, a new clean, empty Ziploc bag. And with his gloved hand and a portion of the field kit, he endeavored to scoop it up and place it in the evidence bag.
There wasn't any testimony about like if he often uses the hood of his patrol car for this purpose. Like, how does he sterilize his patrol car after? There wasn't any evidence along those lines, right?
There was not. There was evidence. He testified that the hood of the car was clean. It appeared clean to him. But I'd also note that what was happening here is the hood of the car was not being used as a microscope slide or as some mortar and pestle in a pharmacy. That's not how he would normally use it. And so in a normal circumstance, when he's field testing a substance, he might gather the evidence from the car that he stopped or wherever it was, and it may be placed on the hood of his car, but he's not normally scattering the drugs on the hood of his car. So even though he conducts other field testing at the hood of his car, it wouldn't be an ordinary circumstance that field testing would introduce that substance to the surface of the hood. It did in this case, and Officer Steele was obviously frustrated. That's evidenced by the body cam footage and by his own testimony. It was frustrating for him. It was entirely unintentional. It only detracted from his investigation. And to that end, that's precisely why this this sequence of events goes to the weight of the evidence that would be determined by the fact finder. And so the officer testified about how this all played out, both in the suppression hearing and at trial. And defense was able to make hay of that in impeaching him at trial about how this could have introduced contaminants and how this was not an ideal situation and so on. The defense was still able to elucidate all those facts in the trial and use that against the state to attempt to sway the jury in the amount of credibility that they would place on the lab report. So the lab test results were still properly admitted in the trial, and the defendant was able to impeach those and draw credibility determinations about them. So finally, the Brady violation, the state maintains there was absolutely no Brady violation that was committed here. First off, the idea that this previous stop would be favorable to the defendant in a sense is belied by the redacted video that was played at trial, which removed the discussion between Officer Steele and the defendant about having realized they had been acquainted a few weeks earlier in a different stop. That was all kept from the jury for obvious reasons. That previous stop was not in any way favorable to the defendant. The fact that the officer had an interaction with this defendant on a previous stop, found a substance and field tested that substance and got a negative result was not exculpatory to the defendant. Furthermore, it doesn't conclusively establish that Officer Steele made any mistake in that previous stop. Those field tests, as this court is well aware from a plethora of cases, those field tests are not conclusive results. They're not lab confirmed. They're not used as evidence against a defendant in a trial for very good reason that we use the lab results for those where they conduct them in a accredited environment. But the fact that Officer Steele obtained a negative result in that earlier stop does not conclusively establish that that substance that he was testing was not methamphetamine in the earlier stop. Everything about that earlier stop was inculpatory to the defendant other than the field test result. But the fact that that earlier stop happened was the defendant was obviously well aware that it had happened. Officer Steele was aware. The body cam footage that was released to the defendant in this case made it clear that the two had had an earlier interaction. While the reports of that earlier interaction were not included in the discovery with this case, that was of no effect to this defendant because he would have been able to make no use of those reports in this case. It was neither favorable nor was that information that was not provided to the defendant, nor did it bring about any prejudice to him. It wouldn't.
Counsel, the argument was that this demonstrates potentially some bad faith on the officer's part. Could you address that?
I'll address it to the extent that I see that the claim was raised. I struggle to to delineate how that evinces any bad faith by Officer Steele. And to the extent that the record here on review by this court draws any conclusions about that, the district court explicitly found officers that there was no bad faith on behalf of on the part of the state here. That's in the record on the suppression hearing.
But that was before this, that was in the absence of this previous report. That previous report was before the court.
But I struggle to ascertain where the bad faith came in that the report was not beneficial to the defendant, other than that he was released and no charges were filed in that earlier event. But the moment it all came up in court, it came up, I believe, in the motion to suppress hearing. At no point did the state prevent the defendant from having a discussion about that with the officer. I believe at some point the state finally objected to questions along those lines and objected on relevancy, but not in an effort to hide or withhold this information from the defendant. Bad faith would require some intentional conduct by the state to withhold this information from the defendant that was obviously plainly exculpatory or favorable to the defendant. But there was no such effort undertaken here. It's not normal course for the state to, when it files a case against a defendant, to dig through all of its archives and records of all of the agencies in the metro to see if they have ever stopped this defendant. And if so, provide those reports and video and evidence, and then tack it on into.
This is a little bit different because it is close in time and it involves the exact same two people. So it's not like
True.
Having to dig everything out. It's, when you're interviewing your witnesses, you say, well, I just stopped this guy 3 weeks ago.
True. And so we could draw a parallel for a smaller county west of Johnson County then, where I would imagine it's much more common where a law enforcement officer has an interaction with the same defendant. I don't know that it's common course there for the prosecuting attorney to gather all the reports from all the previous interactions and put them together in one packet. If that was significant, then I'd be curious where the court would draw the line on what the state needs to provide. If it was a stop within the last month, if it was a stop with the same agency, but not other agencies in the metro, if it was a stop with the same officer, but not other officers, and so on. There's not a reasonable way to delineate as much. And there's also no need for this court to do as much because nothing about that was exculpatory. Nothing about it was favorable to the defendant, and no prejudice befell him as a result of the state not disclosing as much. So recognizing the clock is encouraging me to wrap up, I would ask this court to affirm the district court's ruling on the motion to suppress and affirm the defendant's conviction and sentence in this case. Happy to stand for any additional questions the court may have.
Any other questions from the panel? All right. Well, thank you very much. I want to commend both attorneys on your use of time in this matter, but Ms. Tran, you have 3 minutes for rebuttal.
May it please the court, I'll address the extension of the stop issue. There was a question about what would be the purpose of searching the car at the initial point of seeing the open container, because the open container was right there.
But then it wasn't.
But then it wasn't, which is true. And I think that difference is important because in the interim, so the bottle was there and then the bottle wasn't there. And in the interim, there was a call for the canine to come. And while it's true that there was testimony that the canine officer was close, there was also testimony that Officer Steele would have called a canine to the scene regardless. And so I think it seems pretty clear that he wanted a canine there and he wanted a sniff to be done. And there is case law that talks about when a stop has been extended, if the officers discover some evidence afterward that would make it legal for them, to search, that's not going to be saved by the inevitable discovery doctrine because that stuff was discovered after the stop was already extended. And I think that's what happened here. When first we have the bottle that's in plain view that we see it, we have an officer go back to the car, run the checks, start writing the ticket, call the canine to the scene, stop writing the ticket, disengage from the traffic mission, go to have the car be searched or to be sniffed by the canine, and then see that the bottle has been moved. And then, maybe we have probable cause to search for that bottle, but the car stop has already been extended and we already have, an illegal seizure. And so I think that in that situation, the case law says that inevitable discovery does not save the evidence that is found afterward because we already had an improper seizure at that point.
But he had probable cause to search the car when he saw the bottle. Didn't matter whether it was moved.
And we would disagree and question that he had probably.
You wouldn't?
You know, why would that?
Why would they be? Go ahead.
Because I think we have probable cause to search for the evidence of that crime, which is the bottle that's in plain view and sitting right there. I don't know why, when we have a bottle that's plainly in one place, why we would search for that bottle in other places in that car to find evidence of that crime that was seen.
But wouldn't he have the right to search the car to see if there were other bottles?
I don't think that would be the case, given that just the evidence of the infraction or the crime that was committed is plainly viewed in that circumstance. It's right there. We don't need to search for it. And unless there are further questions, we would ask that Mr. Mendoza-Rodriguez's convictions be reversed. Thank you.
Thank you very much. Further questions from the panel?
No.
All right. I want to thank both counsel for their arguments today. And thank you for your written briefs. We'll take the matter under advisement, issue a decision as soon as we're able.